The state wants the Gqeberha High Court to allow it to take the Timothy Omotoso case to the Supreme Court of Appeal. It argues Judge Irma Schoeman didn't consider the full picture during her prior ruling.
The issue is whether what we ask you to reserve are questions of law. Whether they succeed or not, whether there are reasonable prospects of success or not, that's something that we'll deal with when we come before the Court of Appeal. In fact, that will not even be the test, because then we will be going to that court should you reserve these questions, simply on the basis that we are before the appeal court on the basis of a notice of appeal.
But the defense says the judge was right in her ruling, arguing that the state failed to prove its case.
So what they are suggesting is that unless you had found that the accused's fair trial rights had in fact been violated by the misconduct, you were required to disregard the misconduct in making the findings in which you did in this matter, my lady. That is the essence of that argument.
The defense further argued that the case is closed and that the state's application lacks merit.
The application, in my respectful submission, my lady, is devoid of substance and serves no practical purpose. It should be dismissed in its entirety without a finding that none of the six questions constitutes a question of law within the meaning of Section 319, and that no reasonable prospect exists that any correction of law could lead to conviction.
But the state continues its application is based purely on points of law.
Ultimately, the submission we make, my lady, is that what we propose to you is not at all factual issues. It is questions of law, and as I've said it, I think 2 times before, my lady is not bound to frame them in the manner in which we propose them. But what is important is to keep to the standard. And secondly, what is important is to realize that prospects of success on appeal have no role to play before you. You don't have jurisdiction to deal with the matter on that basis. The only question really is whether, as the SCA has said, what we have proposed as questions of law is in fact questions of law.
The NPA says it's confident that justice will prevail.
We believe that we've made a case for the judge to consider that we must be granted leave to appeal her decision to acquit the 3 accused. As the NPA, we remain committed to ensuring that the victims of these crimes do find justice. For that, we are willing to take the matter to the highest court in the land, because we believe that the outcomes of this case have far-reaching implications on the criminal justice system. Because here we have an issue where we believe that crucial evidence was never considered.
For now, both sides will need to wait for a decision on whether the state will be given another chance to argue its case before the Supreme Court of Appeal. For Newzroom Afrika on Channel 405, I'm Sipha Kema at the Gqeberha High Court.